I'll come to that later. We're at a stage, Malad, where a CO is issued.
The Constituent Assembly is untrammeled.
That's right.
It's as if it is working on a clean slate.
That's correct. That is not bound by anything. Bound by the representatives of the Constituent Assembly who have common aspirations to draft a constitution for the future of the people of the country. Which is why diversity, protection are fundamental to our constitution. For this reason, this very reason. So you want to take away that, that's very dangerous. I'm not being political, but that's the worrisome part. I read 620 minutes.
20.
Now, coming back to Article 368, it may be noted that it has three components. Firstly, it deals with the amendment of the Constitution. Secondly, it designates the body or bodies which can amend the Constitution. And lastly, it prescribes the form and the manner in which the amendment of the Constitution can be effected. The article does not expressly confer power to amend. The power is necessarily implied in the article. The article makes it clear that the amendment of the Constitution can only be made by Parliament, but in cases falling under the proviso, ratification by legislatures of not less than one half of the states is also necessary. Normally, as if you read the proviso, if you don't have the ratification, there'll be no amendment. You can't wish away the proviso. That article stipulates various things. To start with, the amendment of the Constitution must be initiated only by the introduction of a bill for that purpose in either House of Parliament. It must then be passed in each House by a majority of the total membership of that House, and by a majority of not less than 2/3 of the members of that House present and voting. And if the amendment seeks to make any change in the provisions mentioned in the proviso, it must be ratified by not less than one half of the state legislatures. Thereafter, it should be presented to the President for his assent. It further says that upon such assent being given to the bill, the Constitution shall stand amended in accordance with the terms of the bill. To restate the position, Article 368 deals with the amendment of the Constitution. The article contains both the power and the procedure for amending the Constitution. No undue importance should be attached to the marginal note which says procedure for amendment of the Constitution. Marginal note plays a very little part in the construction of a statutory provision. It should have much less importance in construing a constitutional provision. So, Mullahs, when your lordships talk about temporary mullahs, really you have to look at the Constitution. Because it had to be temporary in 1950. There was no element of permanency. It could not have been. And this is the marginal note. Give it to my lord. You have copies?
This is a marginal note. There's no question about it. It is a marginal note.
Yes. So, Mullahs, you can't be saying, which is what your lordships are concerned with, but it was temporary. But that's only when you look at the marginal note. It had to be temporary because there was no other way to deal with it. You couldn't have said it is permanent.
But there's no doubt still about the fact that this forms a part of Part 21 of the Constitution, which still deals with temporary and special provisions.
I'm not disputing that. These are all different provisions, Malad.
They've all been clubbed together in Part 21.
That's correct. But we looked at it in the context of, Malad, what was going to happen in the northeastern regions. Gujarat and Maharashtra together, what was to happen there, issues of Marathwada. So those councils had to be created, boards had to be created. That's why they were temporary. Telangana, that's why they were temporary. Not for any other reason. And that's why this was also temporary. It's the same logic. But the fact that it is temporary doesn't mean that the article is temporary for all time to come. You can't interpret the marginal note in that fashion. So the language of 368 to our mind is, I'm sorry.
317. Did it actually do? Did they yeah, actually they put क्या उन्होंने?
If you look at the heading, Millers, it says temporary and transitional provisions. So 2 is temporary and 2 is transitional and 3 is temporary.
It's 368 power, right?
In this case, no, 356 power. No, it's 356 because they converted. What happened? Well, let me just, in one sentence, they say, in one sentence, I'll tell you what they did. They converted the Legislative Assembly into the Constituent Assembly, right? Right, dissolved. They converted it into a Constituent Assembly. Then they said that now Parliament, because of 356, Parliament is exercising that power. So the Parliament is the legislature. And because it's a Constituent Assembly, Parliament of India is the Constituent Assembly, and therefore we can do what we do. That's in one sentence what they did. And they recommended to themselves. So instead of clapping by 2 hands, they clapped by 1 hand. Because they exercise the power of the legislature themselves. And because the legislature's consent was necessary to give that consent to themselves and abrogated 370. Unique, constitutionally a unique, unheard of. I will not use that expression. A procedure that is unknown to law. Because the objective was entirely different. And I've been saying that from day one.
That's how they brought in the